Every witness's honesty is, of course, a matter of concern for the jury. The jury, after all, is charged with deciding which witnesses are credible on each material fact. Naturally, a witness's character for truthfulness is not subject to Rule 404's general bar on propensity evidence. Article 6 of the Federal Rules of Evidence deals with witnesses generally, including how they may be impeached. To impeach a witness is to attack her credibility. Even though character evidence regarding a witness's truthfulness is admissible, the rules of evidence prohibit bolstering a witness's testimony. Bolstering occurs whenever a witness testifies that, in his opinion, another witness's testimony was truthful or accurate. Such testimony is allowed only in rebuttal. The witness's honesty must first have been attacked, either on cross-examination or by another witness's testimony that the witness is dishonest. If there is no suggestion that a witness's testimony was untruthful, no witness can testify and no party can argue that it was truthful. As the advisory committee explained, the enormous, needless consumption of time which a contrary practice would entail justifies the limitation. The rule distinguishes between credibility and character for truthfulness. Credibility means believability. Character for truthfulness means honesty. A witness's testimony may not be credible or believable for reasons having nothing to do with whether the witness is honest. The Supreme Court listed some of them in the Ottawa, decided in 1865. A witness may not be credible because the witness made a mistake, leapt to conclusions, misunderstood or misremembered the situation, or has some interest in the outcome of the case. None of these implies dishonesty, but each is a reason to doubt that the testimony is accurate. Rule 608 allows character for truthfulness to be shown in the same ways as Rule 405 allows character to be proven generally. Like Rule 405, Rule 608 generally allows honesty to be proven only by reputation and opinion testimony. A witness can be cross-examined about specific acts reflecting on his honesty. A character witness can be asked about specific acts committed by the person she testified about. Specific acts reflecting on a witness's honesty cannot be proven except by cross-examination, unless those acts resulted in a criminal conviction. If a witness denies having committed a dishonest act, the cross-examiner cannot introduce records or another witness's testimony to contradict the witness on that point. Instead, the cross-examiner has to rely on the jury inferring that the witness is lying. Rule 609 deems a conviction for any crime punishable by more than 1 year in prison, which is usually what separates felonies from misdemeanors, relevant to honesty. The rationale is that a felon is less likely than a law-abiding person to be deterred by the threat of a perjury prosecution. Evidence that a witness committed a felony is subject to the usual Rule 403 analysis, except that a criminal defendant's convictions are admissible only if they are more probative than unfairly prejudicial. Evidence that a witness was convicted of a crime, even a misdemeanor, which necessarily entails dishonesty, is always admissible. There is no need to consider Rule 403 because the probative value of such a conviction is as high as can be. Convictions for crimes requiring lying, like fraud or perjury, are especially probative of a witness's honesty and cannot be excluded. The oath has traditionally, as much for religious reasons as for the threat of perjury, been considered indispensable to the admission of testimony. However, evidence about a witness's religious beliefs is not permitted to show anything about the witness's credibility except bias. If a temple or church or other religious group is a party, and the witness is a member of that congregation, for example, That could be shown because, as the Supreme Court held in United States versus Abel, bias is always relevant. It would mislead the jury to let a biased witness appear to be disinterested or impartial. After John Abel and Kurt L. robbed a bank, L. agreed to testify against Abel. Abel wanted to call Robert Mills as a witness. Mills would testify that L. had falsely incriminated Abel to get a good deal for himself. The government wanted to then call L. in rebuttal to explain that all three were members of the Aryan Brotherhood, a notoriously violent white supremacist prison gang that required Mills to perjure himself on Abel's behalf. Abel objected, arguing that having the jury know that he is a racist and violent gang member would be unfairly prejudicial. The district judge allowed the rebuttal evidence except for the most inflammatory details. Trial judges can limit how evidence is presented to mitigate unfair prejudice. The Supreme Court unanimously held that evidence of Abel's and Mills' common gang membership and the gang's rules and enforcement methods was necessary for the jury to understand why Mills might be biased toward Abel. The court's opinion defines bias to mean a relationship between a party and a witness. Once juries understand the relationship, they can infer the bias as well as its strength. A jury, for example, would expect a mother who was a passenger in her daughter's car during an accident to see the situation sympathetically to her daughter. That does not mean the mother will lie. It means only that the mother is not impartial. Being financially or otherwise dependent on a party is likewise a relationship that gives rise to bias. For that reason, expert witnesses are cross-examined about the money they earn from testifying, and criminals testifying for the prosecution are cross-examined about the deal they are getting for testifying. Abel arose long after the Supreme Court had reaffirmed that courts cannot preclude cross-examination meant to show bias. In Alford versus United States, the court held that the government could not prevent cross-examination about the deal it had made with a witness who was charged with a federal crime. 4 decades later, it held that the Confrontation Clause guaranteed that right. In Alford, the trial judge prevented the jury from learning that the prosecution's witness was testifying in exchange for a deal in another case. The judge believed the defense was arguing that the witness was dishonest and ruled that a mere charge was inadmissible to show that. The Supreme Court reversed, holding that the fact that the witness was charged with a federal crime gave him a reason to testify favorably for the prosecution, and that the jury needed to know that. It didn't matter that the witness's charges were unrelated to the defendant's case. The important fact was that the witness was not impartial because the government had power over him. The court also held that, under the common law, the trial judge's ability to control cross-examination was limited to preventing merely repetitive or harassing questions. Trial judges have no discretion to prevent the legitimate impeachment of any witness. Rule 611 codifies that bit of common law. The same idea appeared in Davis versus Alaska, which affirmed the importance of wide-ranging cross-examination to adversarial trials. The issue in Davis was different than the issue in Alford. Alford originated in federal court and might well have decided only an issue of federal common law. It was not until 1965 that the Supreme Court held that the Confrontation Clause applies to the states through the 14th Amendment's Due Process Clause. The question in Davis versus Alaska was whether Alford's holding was implicit in that constitutional provision. Specifically, the Davis court had to decide whether Alaska's asserted interest in keeping the names of juvenile offenders secret justified denying the defendant an opportunity to cross-examine teenager Richard Green on his possible bias. The problem was exacerbated because Green, knowing the judge had ruled that his juvenile conviction could not be mentioned, testified, likely falsely, that he had never before been questioned by police about a crime. Davis held that Alford's rule, which it quoted, is rooted in the Sixth Amendment's Confrontation Clause and applies in state as well as federal prosecutions. That holding, however, was not unanimous. 2 justices would have left Alford the rule in federal court, but not state court, claiming that the truncated cross-examination raised no constitutional issue. One of those 2 justices was Justice William Rehnquist. 10 years after Davis, Justice Rehnquist wrote the opinion holding that Alford protects not only a defendant's right to cross-examine prosecution witnesses, but also a prosecutor's ability to show that a defense witness is biased. The reason given was that every jury is entitled to all information concerning credibility. The court noted that unlike evidence of specific acts reflecting dishonesty, bias can be proven extrinsically if the witness denies it. That is why, when Mills denied knowing anything about a gang, the government was able to recall L to tell the jury all about it.